One question I get asked a lot is, if my spouse earns way more than I do, does that mean that maybe they have an edge when it comes to, custody, residential time? Or is that not factored in? Well, it's an interesting question because, no, their money should not be factored in when we're looking at a parenting plan. Now, that being said, if there is such a large disparity in the two homes, it is likely that there's going to be some type of deviation in the child support order so that those homes are not necessarily equalized, but they're made less disparate. But from a parenting standpoint, the amount of money one parent earns versus another is not going to dictate a parenting plan. A parenting plan is very much set up on the best interests of the children, looking at the child's developmental level, what makes the most sense as far as weekly transitions go. Is it a young child that needs those transitions so that they're seeing their parents more regularly because that is their developmental stage? Or are we talking about teenagers where they don't need to see their parents every week, multiple times? They remember who mom and dad are, even if they're doing a week on, week off schedule. So that is one area about the disparity of income that I'd say you don't need to worry about when you're thinking about developing a residential schedule and a parenting plan for your family. So if you and your spouse, have maybe lived a nice lifestyle where your children are involved in extracurriculars, they might be in private school, and these are things that they've been used to for years. And all of a sudden you're getting a divorce and you wonder, well, is private school still going to be on the table? Are they going to be able to keep up their club lacrosse or their club volleyball? Or is all of a sudden this all going to be different? I have to say that the courts are very inclined to maintain the status quo in many of these areas so that the children are not suffering the loss of the divorce. Now, that being said, of course, once you have established a parenting plan, you cannot unilaterally decide what is going to happen in the other home. Now, something like private school tuition, that is something that likely would be subject to your alternative dispute resolution clause in your parenting plan. So if there is, a bit of a battle about whether or not, Johnny is going to stay in private school, actually bringing that to the mediation table is often the thing to do so that we can understand, where are you coming from? Where are they coming from? And are we going to be able to bridge that gap? So when we're thinking about the best interest of the child, even in like a high net worth divorce, it's quite similar as it is in all other areas. We're looking at things like the child's relationship with parents, how the child is doing in their various settings, whether it's school, extracurricular, medical. So really, again, I would say that the financial piece of this is not really an overlay to the best interest factors, but the court is going to look and take a holistic approach when they're determining what are the next steps, like what are the next steps as far as a parenting plan goes. And so really understanding what makes sense for that child and that family in that exact time frame, that's how a parenting plan is going to be developed. And I would say that one thing that is really beneficial to families who do have more assets is your ability to utilize neutral experts to help you so that you don't have to feel like you're on an island all by yourself as you're navigating some of these things. You can look to some experts to help you develop a parenting plan that is perfectly suited to your children. Sometimes you have parents where both parents, have big jobs. They've been, earning their entire careers, and they might split up. And we might be looking at a situation where we have two families with, pretty high assets on both sides. But sometimes there's this thing where parents get this idea that, oh, if I have the better house, or maybe if I have the house even closer to the school, somehow that is going to be this winning factor, and that's going to make a big difference. The court is not going to look at, your house situation and say, oh, well, you have a bigger, better house and you're 2 blocks closer to the school, so by all means, you should have, more time with the children. I would say that, those types of distinctions are not part of the best interest factors. And so you don't need to worry about if maybe you're the parent living in the smaller house. Now, obviously, this is all relative. There's a big difference between two houses that are perfectly suited, developmentally appropriate for children versus a situation where maybe one parent has that type of house that's developmentally appropriate and one parent might live in a studio apartment with 4 children. That now we're talking about, it probably does have some impacts on the best interest of the child. If you have any questions at all about how your high net worth might layer into any type of questions related to residential schedules, parenting plans, please reach out to us at Elise Buie Family Law Group so we can talk through some of those issues and help alleviate some of your fears.